Test Palais Wilson, ground floor pour le webcast. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. Cabine anglaise, canal 2.
Good morning. I'd like to welcome you to meeting number 4235 of the Human Rights Committee. This is a public meeting and is being webcast. It is devoted to the continuation of consideration of the fourth periodic report of North Macedonia, submitted under the simplified reporting procedure. Mr. Propopenko, head of delegation, will have 15 minutes to continue with your outstanding replies. Thereafter, I will give the floor to a number of members of the committee to pose their questions on the second half of the list of issues prior to reporting, namely issues 13 to 26. As yesterday, your delegation will be granted a 15 minutes break to prepare your responses to the questions posed by members. You will then have 1 hour to deliver your replies. Thereafter, there will be time for follow-up questions and answers. The meeting will adjourn at 13 hours. Without further ado, I now give the floor to you, Mr. Prokopenko. You have the floor.
Thank you, Mr. Chair. We will start by answering questions immediately. Yesterday, we agreed to answer the questions by the order as they were asked. The first one to answer will be Mrs. Kadria from the Ministry of Education. Thank you once again. I will continue where I stopped yesterday. I will repeat that the conclusions and recommendations from the analysis will guide us in amending specific laws and in harmonizing them with the EU acquis on equality and non-discrimination. In accordance with the assessment of the implementation of the national strategy on gender equality, it can be noticed that gender-based stereotypes about women are widely spread. Therefore, one of the recommendations for the work of gender equality mechanisms is that public policies, budgets are designed and implemented with obligatory gender analysis with due consideration given to the needs of women and men in order to produce benefits for all. Then to reduce hate speech and gender stereotypes, promotion of gender-sensitive campaigns, promotion of equality of men and women, and to promote institutional support of women and their appointment to management and leadership positions and promoting equality in the decision-making bodies. Anti-gender equality movements worldwide and in North Macedonia appeared in 2023. When we had the public debate on gender equality, we explained the responsibilities and duties set forth under the then draft law on gender equality, all with a view to raising, among other things, public awareness about gender equality. According to the report of the Parliament of North Macedonia in the period 2023-2024, the number of women hasn't changed. Number of MPs are 47, 39%. We have 3 ministers women, while at the local level, the situation hasn't changed. 8.36 of mayoral candidate are women. Under the new strategy for prevention of violence against women and against domestic violence, we have expert support. One of the experts is a specialist on countering digital violence. So under both action plans for the implementation of this strategy, we are going to have provisions of provisions on countering digital violence. Svetanka Tsureva from the Ministry of the Interior. Good morning. Yesterday, we mentioned the issue of use of force, excessive use of force against the Roma. We have internal control department, which is in charge of receiving reports against excessive use of force by police officers. However, this unit does not keep data segregated according to the ethnic affiliation of persons filing the reports. So we don't know how many Roma, Turks, Serbs or Macedonians have filed a report. So all reports are equally applied when processing. All laws are equally applied when processing all reports. So, regarding the refugees, we apply the law on international and temporary protection, which is in line with EU directives. Refugees or asylum seekers are first accommodated in open accommodation centers. They are free to leave those centers, and most often these refugees transit through our country. No asylum seeker has been rejected their application without reasonable grounds. So this fact is further supported by the fact that the UNHCR office in our country controls the procedure we apply with respect to refugees, and thus far we haven't had any objections from the UNHCR office. Another mechanism that refugees have available to protect their rights is filing an application with the European Human Rights Court. We have another transit center of closed type for refugees. The center has been visited by the ombudsman, and the ombudsman hasn't had any remarks. NGOs have access to this closed center. They provide assistance, plus refugees have the second instance administrative court to apply to in case of violation of their rights. So we haven't had any report on excessive use of force against refugees thus far. Mrs. Kikerikova. Regarding the emergency situation during the COVID pandemic, there were 5 decisions adopted by the president declaring emergency situation. There were also 250 government decisions adopted. We applied at that time Article 54 of the Constitution, allowing for limitation of freedoms and rights of citizens, which corresponds with Article 4 of the Covenant. Under these government and presidential decrees, all rights of citizens were respected during the emergency situation. Courts continued. Courts stayed their work during the pandemic. We believe that these documents enacted during the pandemic did not have the effect of suspending constitutional rights, except that there was a stricter regime of movement of citizens. As regards the direct application of the covenant by the Constitutional Court, we have a ruling of 2014 of the Constitutional Court, which is quoted in our report, and it applies to application. The ruling refers to application of relevant provisions of the covenant on issuance of passport or visa if a person has been returned to the country because of violating conditions for entry and stay in that foreign country. There were strictly defined conditions under which exit from the country was not allowed. So it was done for the purpose of protecting public health and security. The court assessed that this is excessive and too strict application of the legislative framework, and referring to Article 12 of the and paragraph 2 of the law of the covenant, the court ordered suspension of previously adopted decision banning exit from the country. In the meantime, we have statistics about remand prison. Yesterday, we elaborated upon the legal grounds for remand prisons. I can tell you that in practice, we apply alternative measures such as house arrest and a bail. We have organized numerous trainings for judges and public prosecutors on the application of alternative measures alternative to remand prisons. As regards complaints, I can tell you we have effective complaints, especially in the last period. There is a trend of abolishing remand prison when an appeal against a remand prison has been filed. This can be supported with numbers. In 2024, out of a total number of 20,103 remand prison cases, remand prison has been ordered in 628 cases, which is 3.1% of the total number of cases, which this percentage in 2023 was higher, 3.6 cases of remand prison out of the total number of cases. Yesterday, we mentioned the issue of excessive use of force, which greatly damages the reputation and renown of our country. So we are working on improving the legal provisions governing excessive use of force, and very promptly these provisions will be in parliamentary reading. The Constitutional Court has also instituted proceedings regarding the amendments of the Criminal Code dated 2023. In cooperation with the OSCE and OSCE experts, we drafted amendments to provisions against torture and abuse of office. Plus, we had the problem of statute of limitation of cases of excessive use of force under the Criminal Code. It was a secret deal making between the police officers and the public prosecutors. So the new amendments prevent statute of limitations for cases of excessive use of force and torture perpetrated by police officers. So the possibility for abuse has been removed. And we have ensured another guarantee. The Department for Internal Control at the Ministry of the Interior is not allowed to undertake any action in order not to compromise the investigation of the public prosecutor's office, and has to wait until the public prosecutor's office has secured all evidence required for the case. After that, the Ministry of the Interior or the Department for Internal Control may institute disciplinary proceedings. And we have a provision that in the investigation of cases of excessive use of force and torture by police officer is not led by the Ministry of the Interior, but the Public Prosecutor's Office using their own investigators. And Public Prosecutor's Office has investigated 424 cases of excessive use of force and torture, not only by police officers, but also members of other law enforcement bodies. Thank you.
Now I will move to the second round of the questions by the members, and I'll give the floor first to Mr. Carozzo.
Muchas gracias. Muy buenos días.
Thank you very much indeed. Well, good day to you all. In this productive session, Articles 14 or Issue 14, namely trafficking in persons, is what I will address. North Macedonia has made huge efforts in combating trafficking in persons with a plan of action 2021-2025 and a specific plan for child trafficking regarding victim identification, protection and compensation of victims. The framework has been notably strengthened, including through amendments for severe penalties on child exploitation, as well as the embodiment of the non-punishment principle for victims, as well as the 2018 Foreigners Law or Foreigners Act, which grants temporary residence and period of reflection periods. And also something that should be applauded, namely the 2022 law on payments of monetary compensation to victims, where specialized centers are provided for sheltering, particularly for women and girls. In 2021, there was a rise in the number of victims, but that, I assume, reflects the fact that your identification methods are better, but it also underscores the scale of the problem of trafficking in persons. This committee takes note of this new strategy to combat trafficking in persons, the 2021-2025 one. But there are reports of ongoing complicity by the police, and that's a cause for concern. So we would like to ask you, what are the oversight frameworks? Do you have sound, independent oversight frameworks to prevent, prosecute, and effectively prosecute, rather, this alleged complicity with the police? With regard to the victims of trafficking, especially aliens and minors, could the state party describe the specific policies on non-repatriation that you have and long-term support mechanisms that you might have? Also, what measures are in place to ensure that victims receive prompt access to adequate compensation, as well as appropriate rehabilitation and psychosocial assistance, and this consistent with international standards? Also, What specific and preventive measures is the state party implementing to address the root causes of and demand for human trafficking in persons, and how are these initiatives aimed at strengthening vulnerable groups? I'm referring here to addressing poverty, addressing lack of education, and what you are doing to address social marginalization in order to reduce risk to trafficking. What specific measures has the state party implemented to enhance the proactive identification of adult victims of trafficking in persons among particularly vulnerable groups such as migrants, the Roma, asylum seekers, all those in an irregular employment situation? Moving on now to issue 26 of the list of issues, namely participation in public affairs. If you look at the legal framework, we see that it has constantly been upgraded for it to be aligned with the ORID agreement on governments. Political representation actually reflects this, as we have heard and as can be seen in the results of the 2020 parliamentary elections, wherein out of 120 members of parliament, 78% are Macedonians, 78 are Macedonians, 32 are Albanians, 3 are Turks. According to what I've been told, there are no Roma members of parliament. There is one from Serbian origin, one from Bosnian origin, and one black, and a lower number of ethnic groups also. In 2020, the Ombudsman's report, whose absence rather is noted here, indicates a trend of increased representation for ethnic groups in the public sector from 2007 to 2020. In fact, in 2020, the Ministry of Political Systems and Inter-Community Relation was asked to coordinate government support for the framework agreement, that is the ORID agreement, and to secure necessary financial resources. Now, the law on the use of languages adopted in 2019 says that Macedonian and the Cyrillic alphabet are the official language and alphabet across the entire territory, but it also says that any language spoken by at least 20% of the citizens of North Macedonia is also an official language as well, and they have the right to use these official languages, and institutions are obligated to enable their use in all procedures. The progress in representation is positive. However, we still have the persistent question of resource allocation to specific ethnic community-focused institutions, which is an issue which remains unaddressed in the report. So our question would be, whilst we recognize the commitment of the state to creating an inclusive and multi-ethnic society, at the same time, the committee is concerned about the lack of funds and staff for the main agencies responsible for the rights of minorities, such as the Agency for the Realization of the Rights of Communities and the departments that support education in community languages. Now, could the state party describe concrete plans and budgetary allocations with specific deadlines that you have to tackle these limitations? Now, beyond general demographic data, what comprehensive and disaggregated data collection mechanisms what comprehensive and data collection mechanisms does this state party have to effectively monitor the enjoyment of rights of all ethnic communities, particularly smaller or less recognized groups within the multi-ethnic society? How is this data actively utilized to inform targeted policies and ensure that specific needs and challenges of all minorities are adequately identified and addressed? Now, beyond linguistic plurality and political representation, how does the state concretely ensure the effective protection and promotion of the distinct cultural and religious identities of communities, including smaller groups within society, and also what specific measures are in place to support and also celebrate their active participation in cultural life. Moving on now to the context of the inclusive and multi-ethnic society, what special measures has the state party adopted and implemented to ensure the preservation and promotion of Macedonian culture, language, and national identity, while simultaneously respecting and supporting the diverse cultural expressions of all other ethnic communities? Now, moving on to an issue in the list of issues, which is ill treatment of children with disabilities, which is in addition to what my colleague Ms. Lenata has said. No, actually, I will leave that topic to my colleague Ms. Lenata. I very much look forward to your answers. Thank you very much.
Thank you very much, Mr. Caruso. I'll give the floor to Mr. Igezu.
I thank you, Chair, and a very good morning to the delegation of Macedonia. My questions for this morning will focus on paragraphs 15, 16, and 17 of the list of issues. Going to my questions on paragraph 15 on freedom of movement, you mentioned in your reply, and it has already been mentioned earlier on also, that the Constitutional Court of the State Party passed a decision in 2012 repealing Article 37, paragraph 1, subparagraph 6, and Article 38, paragraph 4 of the law on travel documents of citizens, effective as of 2014, guaranteeing every citizen of the state party that the right to freedom of movement, which is a welcome development. You also mentioned that 113 lawsuits were filed against the Ministry of Internal Affairs for discrimination based on belonging to the Roma community and violation of the right to movement, and that courts awarded damages to victims in the form of compensation. You also point out that several complaints were filed at the European Court of Human Rights against the state party on similar claims, and that this was agreed to be resolved by a friendly settlement between the state party and the victim, citing 4 cases to this effect. On the other hand, I also understand that on October 24, 2023, the European Court of Human Rights has ruled against the state party in its judgment, Memedova and others versus North Macedonia, finding the 4 of the Romani applicants had been subject to discrimination and that their freedom of movement had been violated, and awarded compensation to be paid to victims amounting to 13,000 euros collectively. It appears from this that denial of the right to movement on the basis of Roma status may have not yet been fully eliminated in practice, despite the decision of the Constitutional Court, and that further measures may need to be taken by the state party to fully guarantee the freedom of movement against the Roma community, including other minorities, and to bring those accountable to justice. Can the state party therefore please provide information on what guarantees it will put in place in practice to ensure that Roma and other minorities are no longer deprived of their rights to freedom of movement at border crossing based on their identity? What measures have been taken to date to bring to justice any border official and other responsible actors who have denied freedom of movement to the Roma community at border crossings in breach of national and international law? What follow-up measures the state party has taken to implement the decision of the European Court of Human Rights in Memedova and others versus Republic of Macedonia, including providing adequate compensation to the victims of the violation? Going to my question on paragraph 16 on aliens and asylum seekers, despite several recent legislative reforms that have been put in place by the state party to improve the treatment and protection of migrants and asylum seekers, information before the committee indicates that asylum seekers still face prolonged waits for biometric IDs and a not assigned identification number until protection is granted, which restricts their access to basic services, including healthcare, employment, and education. Another concerning issue that are extensively reported is the detention of asylum seekers, including women and children at the reception center in Gazibaba and during the COVID-19 pandemic at the temporary transit center in Vinojug. It is reported that two temporary transit centers continue to operate without a formal legal status, and therefore the stay in these temporary transit centers for those not seeking asylum but were held for purpose of providing statements in the capacity of witnesses in criminal proceedings and those in need of medical assistance remains unregulated with limited freedom of movement and limited access to information about their situation and prospects. Can the state party therefore please provide further information on measures it plans to take to ensure that those who have gained refugee status are issued with machine-readable convention travel documents and expedite the issuance of biometric IDs for refugees, persons with subsidiary protection, and for all asylum seekers whose asylum claims have been pending a decision for more than 3 months in order to safeguard their freedom of movement in line with Article 12 of the Covenant, assign personal identification numbers to asylum seekers upon registration for them to have effective access to rights and services, including access to healthcare, education, and employment as provided for by the law on international and temporary protection and in line with the obligations under the Covenant. Ensure the detention of irregular migrants and asylum seekers held solely to testify in criminal cases, with particular focus on ending the detention of women and children, including ensuring legal alternatives to detention are available and effectively implemented in this context. The committee remains deeply concerned about well-documented report of violent pushbacks, collective expulsions of migrants and asylum seekers by the state party, which appears to be a violation of the principle of non-refoulement, including arbitrary and incommunicado detention during this process. Can the state party please comment on these reports? Can you also please provide information on what measures the state party plans to take to ensure that the conduct of law enforcement officers during pushback is in full compliance with the principle of non-refoulement, including information on whether measures have been taken to investigate allegations of pushbacks and the violation of the principle of refoulement. Going to my questions on paragraph 17, the committee welcomes several positive measures taken by the state party towards reducing statelessness and acceding to the 1961 Convention on the Reduction of Statelessness in January 2020, the adoption of the law on unregistered persons in the birth register, including laws adopted in 2023, such as the law on civil registry, the law on ID cards, as well as the law on foreigners, among others. However, while the state party has made progress in preventing statelessness, reports point out that there is still no dedicated statelessness determination procedure nor protection status for stateless migrants residing in its territory. It is also pointed out that implementation gaps in birth registration persist, with unregistered children, especially among Roma children, who are still at heightened risk of statelessness. Lastly, despite legislative provisions for universal birth registration, regardless of legal status, systemic obstacles appear to exist and insufficient hospital-based registration measures exist that hinder full coverage. Can the state party therefore please provide information on what measures it plans to take to ensure that every child is registered immediately after birth and has the right to a name and nationality from birth, including by monitoring implementation of the amended national legislation, continue the effective implementation of the amended law on civil registry, and strengthen measures to register persons with unregulated civil status and provide them with civil documentation, ensure that all status persons, including members of Roma, Ashkali, and Egyptian communities, have access to fundamental rights in law and in practice without any discrimination, irrespective of documentation or citizenship status, including education, healthcare, maternity care, work, accommodation, and protection from rights violations such as child and early marriage, establish a fair, effective, and accessible statelessness determination procedure in law applicable to all persons in the state party, regardless of their legal status, that is fully aligned with international standards and good practices, so as to give full effect to the rights enshrined in the 1954 Convention. This ends my question for this morning, and thank you for your attention. I thank you.
Thank you very much, Mr. Igezu. Now I give the floor to Mr. Quesada.
Gracias, Presidente.
Thank you, Chair, and thank you also to the delegation for the responses provided this morning. I, this morning, will deal with paragraphs 18, 21, and 22 of the list of issues. And I'll start with paragraph 18 on access to justice and independence of the judiciary and the right to an impartial trial. So these are my questions. In the relevant paragraph on the list of issues, several questions were asked. Most of them were replied to by the State Party in its periodic report. However, there is still information missing about the status of the bill amending the law on witness protection. Could you please provide us with information on that? Secondly, you were requested to provide information about allegations on the significant delays in the courts, in particular when it comes to high-level corruption cases where multiple accused persons are involved, including appeals proceedings. Thirdly, similarly, could you tell us about the allegations on a lack of transparency and justification in the appointment and promotion of judges by the Judicial Council? This could attack the merits-based system and lead to favoritism, personal favoritism, perceptions, and political influence in judicial appointments. Fourthly, I would like to receive information about the implementation on the strategy to develop the justice system 2023-2027 and its action plan. In particular, I would like to know whether its implementation has brought about an improvement in access to justice and free of charge legal aid for groups who find themselves in a poverty and marginal situation. And lastly, could you please tell us about what measures have been adopted to overcome the backlogs in dispute settlement when it comes to administrative disputes? Very often the 9-month timeline has been exceeded, established by law, on administrative disputes, as well as a lack of cooperation of the public authorities during the processing of judicial proceedings. I'd now like to move on to paragraph 21 on freedom of conscience and religious belief. We understand that an interinstitutional group led by the Ministry of Justice was established to amend the 2007 Act on the legal status of churches, religious communities, and religious groups. The aim of this bill is to enable subdivisions from broad religious communities, such as churches and mosques, to acquire the status of institutions that are recognized legally, and other reforms to harmonize that law with the provisions of the Criminal Code and other legal texts. I would like to ask the delegation to provide information on that. Please could you tell us the state of play of the draft bill, which started as an initiative in 2017, the aim of which is to amend the Criminal Code to punish anti-Semitism, the denial of the Holocaust, and the glorification of symbols of Nazism and fascism. Could you also provide information about the claims from smaller Protestant churches? They say that governmental authorities tend not to consider them in meetings and public acts. They give privilege to the 5 religious communities that are recognized in the Constitution. In addition, these churches maintain that they face greater administrative difficulties to build their churches and temples. And lastly, we've been made aware of reports of hate speech online on religious grounds, particularly with an anti-Muslim content. Could you please provide the committee about this information about the situation and whether measures have been adopted to combat these practices and identify and punish the perpetrators? I'd now like to move on to paragraph 22 on freedom of expression. Could you please tell us about the appointment of the members of the Council of the Audio and Audiovisual Services Agency. Could you tell us about its composition and how this ensures the independence of this institution? We have been made aware that in 2022 and 23, the Association of Journalists of Macedonia publicly were opposed to several appointments. They allege that appointments were politically motivated, and this constitutes interference, undermining the public trust in the impartiality of the agency. Furthermore, in your periodic report, in paragraph 206, the State Party refers to the law on civil responsibility for insults and slander in 2010. It originally decriminalized insult and slander, establishing civilian responsibility for the perpetrators of these acts. This law was amended in November 2022, and it significantly reduced the maximum amounts of compensation provided for moral damage caused by a journalist or an editor or a legally established body. Could you please tell us whether since its adoption this law has been applied, and if so, in how many cases, on what grounds, and could you tell us about the number of journalists who have been punished or sanctioned? The Macedonian Journalists Association has also informed us that since 2021 to 2024, there were 21 incidents of attacks on journalists and press workers, with minor annual variations. This shows that there's a need for systematic monitoring and ongoing efforts to improve security and protection of journalists. Could you tell us about the measures the State Party has adopted to ensure the security and safety of journalists when exercising their profession and avoid attacks that have affected several of them in recent years? Similarly, please provide information about the training activities for judges, prosecutors, and police officers on journalism and the freedom of expression that have been imparted in recent years. Could you tell us about the content and the number of participants taking part, and whether such activities are ongoing? And lastly, please provide information about the functions and powers of the special prosecutor attached to the General Prosecutor's Office in 2022 to monitor cases where there have been threats or violence against journalists. Those are my questions, and thank you very much indeed for the information in advance that you may provide. Thank you.
Mr. Quesada, and I'll give the floor to Madame Tiguza.
Merci, Monsieur le
Thank you very much, Chairman, and I'd like to welcome the delegation. Today, I'm going to address paragraphs 19 and 20, and these focus on issues of privacy, surveillance, and data protection pursuant to Article 17 of the Covenant. On paragraph 19, firstly, I'd like to come back to the legal and judicial framework, which is applicable to surveillance and the specific methods of investigation and trials underway for illegal surveillance. The committee has taken note of the responses provided by the State Party in its report, paragraphs 173 and onwards. So please, in your replies, do not repeat the report because I read it very carefully indeed. I'd like to ask a number of additional questions which go above and beyond what is written in your report. Firstly, what are the guarantees offered to persons who are subject to illegal surveillance? And given that they are, by the very nature, secret, how can these individuals know that they're being targeted by secret surveillance, and how does the judge intervene in the process? Secondly, what is the status of evidence obtained illegally during a trial? The European Court of Human Rights, as well as the Human Rights Committee, have specific jurisprudence on this point, particularly for evidence obtained violating privacy, whether it be Article 17 of our Covenant or Article 8 of the European Court of Human Rights. Thus, I would like to know what is the possible exclusion regime applicable to them, to the evidence obtained illegally. Thirdly, what is the state of play of the legal proceedings in the Target Fortress cases mentioned in the list of issues and also mentioned by the State Party in its report? Once again, the aim of our dialogue is to go a little further than what the state is saying in its report. On paragraph 20, it focuses on the data protection regime data collection and conservation, which in its substance, according to the State Party report, is aligned with the framework set by the European Union in this respect. Thus, the committee would like to know where you're at in terms of reviewing the guidelines on the applicable procedure by the police and biological material and any other similar reforms underway announced by the State Party in its report. And this is a set of guidelines, some provisions of which have been subject to a conviction by the European Court of Human Rights on the 25th of June 2024 because of a violation of Article 8 of the European Court of Human Rights. And I would recall that Article 8 is the equivalent of Article 17 of our covenant. Furthermore, in the UN 75 pledges, which I mentioned yesterday, the state announced that it would launch a vast digital transformation program of society by 2027. The committee would like to know what this covers specifically and what is the state of play at this mid-May stage. I'd like to thank you in advance for your responses.
Thank you very much, Madam Tiguruza. And I'll give the floor now to Madam Leinarte.
Good morning to the delegation, and I look forward to continuing our dialogue. And today I will deal with two issues, beginning with 23 on rights of the child. In 2024, North Macedonia adopted the law on justice for children, which incorporated the principle of the best interest of the child. It is a solid step forward, especially keeping in mind that social assistance is quite limited to families with children in the country. Only 22.6% of households with children are receiving child or family cash benefits, compared to the EU's 88.4%. The law on social protection mandates services for children with disabilities. However, a recent study indicates that 58% of eligible children receive early childhood intervention services, leaving approximately more than 7,000 children with disabilities necessary to support. Could you please comment on plans to improve availability of services for children with disabilities and their caregivers? This is poverty that causes child marriages, with 46% of Roma girls married before 18. However, despite the important legal changes, amendments to address child marriage are still pending. Could you please comment on legal and policy efforts to abolish child and forced marriages? While North Macedonia has banned all forms of corporal punishment, violence against children remains a problem. The UNICEF 2024 situational analysis reveals a rise in reported violence cases. Almost 3/4 of all children, which is 73%, are exposed to violent discipline at home. Physical punishment and psychological aggression rates are even higher for boys and children with disabilities. Then in 2020, Roma children made up 75% of those in correctional institutions, with cases of the alleged abuse of children in detention and the practice of the solitary confinement of them. What can be done to protect children, all children in the country? Now I move to issue 25 on participation in public affairs. It is commendable that the State Election Commission monitors the implementation of the rights of persons with disabilities, including application of Braille alphabet during voting and elections, also delivering equipment for inaccessible polling stations. That the electoral law includes provisions for inclusion of persons with disabilities in all stages of the electoral process, including registration and participation in political parties' candidate lists as a candidates. We know that small ethnic political parties comparatively well integrated in election process, with the exception of Roma. Yesterday, it was well explained, the strategy of universal birth registration, also the role of special educators to keep Roma children in schools, which are promising preconditions of participation in public and political life of Roma in North Macedonia in the long range. What has been done that persons lacking personal documentation could exercise their active electoral rights now, today? Could you please clarify on how individuals in detention facilities exercise their voting rights? Last year, electoral code amendments, excuse me, were passed through fast-track procedure, right just before the elections. As a result, the dramatic increase in signature requirement for independent candidates took place. The Constitutional Court in May 2025 struck down the Electoral Code amendment after the elections. Such an electoral code uncertainty has an impact on election results. What safeguards are in place that local elections, which are expected to be held in October in the country, will not be affected by similar fast-track procedures? This concludes my questions, and I look forward to the state parties' responses. Thank you.
Thank you very much, Madam Leonarte. These are all our questions this morning. So as agreed, I'll give you 15 minutes to prepare the answers. The meeting is suspended. Dear delegation, I will resume the session. Now, I will give the floor to the delegation. You have the floor, sir.
Thank you. Chair, we will answer questions as they were asked. First, we have representatives of the Ministry of the Interior. Thank you. Excellencies, colleagues, regarding the question about effective prosecution of police officers against whom there are allegations of participating in trafficking in human beings and how these crimes are processed, especially cases in which police officers are involved. I can tell you that police officers are treated as all other citizens. For example, we have convicted, there is a police officer convicted to 4 years in prison under Article